Supreme Court has just delivered an 8-1 emergency decision, and it's sending shockwaves across America tonight. For decades, we've seen razor-thin 5-4 splits decide the fate of the Second Amendment, but this time, 8 of the 9 justices stood together in one of the most stunning and unexpected rulings in modern history. This isn't just another legal twist. It's a turning point that could redefine what gun rights mean in America. What exactly did the court decide? Why now, and why with such overwhelming agreement? And most importantly, what does this mean for your rights moving forward? Stay with me, because this ruling doesn't just shift the law, it rewrites the very future of the Second Amendment and the balance of power between the people and the government. Let's rewind the clock to June 2021. Missouri's state legislature was fed up. For years, they watched as Washington passed gun regulation after gun regulation, restrictions that many Missourians believed violated their constitutional right. So they decided to do something about it. They crafted a piece of legislation called the Second Amendment Preservation Act, and when Republican Governor Mike Parson signed it into law at a gun shop surrounded by cheering supporters, it sent a message heard all the way to the White House. This law wasn't playing games. It declared that certain federal gun regulations were simply invalid within Missouri's borders. We're talking about weapon registration requirements, specific taxes on firearms, and various restrictions on law-abiding citizens owning guns. Missouri looked at these federal rules and said point-blank, "These don't apply here, not in our state." But here's where it got really interesting. The law didn't stop at declarations. It had enforcement mechanisms that made federal agents and the Biden administration absolutely furious. Missouri prohibited its state and local police officers from helping federal authorities enforce these gun laws. And if any officer decided to cooperate with the feds anyway, they could face a $50,000 penalty. That's not a typo, $50,000 for simply working with federal gun enforcement. The law even allowed private citizens to sue any agency or officer who assisted in enforcing these federal gun regulations. Missouri was essentially building a legal fortress around their gun owners and telling Washington that the federal government could enforce their own laws without Missouri's help, manpower, or resources. Supporters called it a brilliant exercise of state sovereignty. Critics called it nullification, a loaded term that harkens back to some of the darkest chapters in American history. But whatever you called it, Missouri wasn't backing down. They were drawing a constitutional line in the sand and daring the federal government to cross it. The Department of Justice under President Biden didn't wait long to respond. They came out swinging, calling Missouri's Second Amendment Preservation Act an obviously unconstitutional attempt to nullify federal law. The legal battle was on, and it would wind its way through the courts for the next several years. The federal government's argument centered on something called the Supremacy Clause, a provision in Article 6 of the Constitution that establishes federal law as the supreme law of the land. When there's a conflict between federal and state law, federal law wins. That's basic constitutional law that's been settled since the founding of our nation. Or at least that's what the Justice Department argued. In March 2023, United States District Judge Brian Weems struck down the entire Second Amendment Preservation Act. His reasoning was straightforward. Missouri couldn't simply declare federal laws invalid and then punish state and local officers for doing their jobs in cooperation with federal authorities. That's not how our constitutional system works, the judge wrote. He went even further, pointing out that Missouri's law was actually making people less safe by interfering with federal laws designed to keep firearms out of the hands of domestic abusers and convicted felons. That was a gut punch to Missouri's argument. But the state wasn't ready to surrender. They immediately filed an appeal to the Eighth Circuit Court of Appeals, and simultaneously, they went straight to the Supreme Court asking for emergency relief. This is where things got really interesting. Missouri essentially begged the justices to let them keep enforcing their law while the appeals played out. Emergency requests like this are unusual, and the Supreme Court doesn't grant them lightly. But Missouri felt they had a strong enough case, especially with a 6-3 conservative majority on the bench, to at least get a hearing. What happened next stunned everyone. On October 20, 2023, the Supreme Court issued its first ruling in this saga. 8 justices, including Chief Justice John Roberts and most of the conservative bloc, said no to Missouri's emergency request. Only Justice Clarence Thomas indicated he would have granted Missouri's plea, but he offered no explanation, just a noted dissent. That 8-1 vote was a warning shot. If Missouri couldn't even get emergency relief with this conservative court, their chances of winning on the merits looked grim. The case continued through the appeals process, and in August 2024, the Eighth Circuit Court of Appeals delivered another unanimous blow to Missouri. Chief Judge Stephen Colloton, writing for a 3-0 panel, laid out the constitutional boundaries clearly. States don't have to help enforce federal laws, he wrote. That principle is called the anti-commandeering doctrine, and it's well established in constitutional law. The federal government can't force state officials to carry out federal programs or enforce federal regulations. That's a legitimate protection of state sovereignty. But, and this is a huge but, states definitely cannot declare federal laws invalid within their borders, and they absolutely cannot punish state and local officers who choose to cooperate with federal authorities. Missouri had crossed a constitutional line that even conservative judges weren't willing to defend. The Eighth Circuit's decision affirmed the lower court ruling striking down the Second Amendment Preservation Act. Missouri was running out of options, but they had one last card to play. In early 2025, they filed a petition asking the Supreme Court to hear the case on its merit. By this point, the political landscape had shifted dramatically. Donald Trump had returned to the White House, and his Justice Department had a more sympathetic view toward gun rights and state sovereignty than Biden's DOJ had. The Trump administration filed a brief that softened the federal government's position slightly, acknowledging some legitimate concerns about federal overreach. But even with a more friendly administration in Washington, the Trump DOJ still urged the Supreme Court not to take the case. They opposed the specific approach Missouri had taken, even if they sympathized with the underlying frustration. Then came the final blow. On October 6, 2025, the Supreme Court declined to hear Missouri's appeal. No recorded dissents this time, not even from Justice Clarence Thomas. Missouri's Second Amendment Preservation Act was officially dead. The legal battle was over, and Missouri had lost at every single level of the federal court system. But here's what you need to understand. This case was never really just about one state's law. This was a fundamental clash between two competing visions of how our federal system should work, and the implications of this decision ripple far beyond Missouri's borders. From Missouri's perspective, they were exercising legitimate state authority to protect constitutional rights they believed the federal government was violating. They pointed to sanctuary cities that refused to enforce federal immigration laws and asked, what's the difference? If California and New York can declare themselves sanctuaries and refuse to help immigration and customs enforcement deport illegal immigrants, why can't Missouri declare itself a Second Amendment sanctuary and refuse to help the Bureau of Alcohol, Tobacco, Firearms, and Explosives enforce gun regulations? It's a fair question, and one that resonates with millions of Americans who see a double standard in how the federal government treats different kinds of sanctuary policies. Missouri argued they weren't arresting federal agents or physically blocking them from enforcing federal law. They were simply keeping their own officers out of it, exercising their right under the anti-commandeering doctrine not to participate in federal enforcement efforts. The federal government saw things completely differently. From their perspective, Missouri wasn't simply abstaining from enforcement. They were actively undermining federal law by declaring it invalid and imposing massive financial penalties on cooperation. That's nullification, the feds argued, and it's a concept with a dark and dangerous history. We settled the question of whether states can nullify federal laws a long time ago, they said, and the answer was definitively no. The supremacy clause means federal law is supreme, period. If you let Missouri get away with this, what's to stop other states from nullifying civil rights laws, environmental regulations, or any other federal statute they don't like? The entire federal system would collapse into chaos. Both sides had principled constitutional arguments, but the Supreme Court overwhelmingly sided with the federal government's position. That 8-1 vote, and then the refusal to even hear the case on appeal, sent an unmistakable message about where this court draws the line on state versus federal power. The political climate matters enormously in this fight. Under the Biden administration's Justice Department, the federal government aggressively challenged Missouri's Second Amendment Preservation Act and pushed for its complete invalidation. When Trump returned to office in 2025, his DOJ softened its position somewhat but still opposed the law in principle. That tells you something important. Even a pro-gun administration that's sympathetic to concerns about federal overreach drew the line at nullification. Elections have real consequences for how hard the federal government pushes gun regulations and how much accommodation gun-friendly states might get, but there are still constitutional limits that transcend which party controls the White House. Trump's Justice Department is already working on other initiatives that gun rights supporters care deeply about. They're reviving a long-dormant process that could allow certain individuals with felony convictions to petition for restoration of their gun rights under federal law. Meanwhile, the flood of targeted legal challenges to specific federal gun regulations continues unabated. Cases challenging the Bureau of Alcohol, Tobacco, Firearms, and Explosives Authority over pistol braces, ghost guns, and other regulatory matters are working through the court. Challenges questioning who can be disarmed under the Second Amendment, like whether marijuana users or people subject to domestic violence restraining orders can be prohibited from owning guns, are reaching the Supreme Court. Tests of weapon-specific bans, magazine restrictions, and sensitive places laws are multiplying across every federal circuit. Unlike Missouri's nullification approach, these cases directly attack whether the regulations themselves violate the Second Amendment. That's the strategy that courts, including this Supreme Court, seem far more receptive to. One thing is absolutely certain. The debate over the Second Amendment, over who can own what kinds of firearms, over how much regulation is too much regulation, over the balance between individual liberty and public safety, that debate is not going away anytime soon. Whether you're thrilled or devastated by this Supreme Court decision, your voice and your actions matter in determining what comes next. This is your country, these are your rights, and the responsibility for defending them rests with all of us. So stay informed, stay engaged, and never stop fighting for what you believe in. The Second Amendment battle is far from over, and every single one of us has a role to play in how it unfolds. That's it for today's breakdown of this landmark Supreme Court decision. I hope this gave you a clear understanding of what happened, why it matters, and what comes next. If this video helped you make sense of this complex legal and political battle, do me a solid and hit that like button. It really does help get this information out to more people who need to understand what's happening with their constitutional rights. And if you haven't already subscribed to this channel, what are you waiting for? We're bringing you in-depth analysis of every major development in the Second Amendment fight, breaking down the legal arguments, explaining the political implications, and keeping you ahead of the curve on what's coming next. Drop your thoughts in the comments below. I want to hear where you stand on this Missouri case. Do you think states should have more power to resist federal gun laws? Do you agree with the Supreme Court's decision? What do you think is the best strategy for protecting Second Amendment rights going forward? Let's have that conversation, because that's how we learn from each other and build a stronger movement for liberty. The conversation doesn't end here, and neither does our fight. Until next time, stay vigilant, stay informed, and keep defending freedom.